So we have a 10th district case, and my name is Kip from Alec Malik. It's JC Emmer-Lovell versus the IC. And this case involves a light duty job offer and whether it is made in good faith. So that's kind of the big meat in this particular case. Um, and what ended up happening is that a mandamus was filed, and then objections were made to the magistrate's decision, and then it was bounced back on again that issue. It was bounced back to the Industrial Commission on the issue of whether the light duty job offer made by the employer was again made in good faith. And the facts of the situation are such that we have this injured worker. He was a utility worker, and what he ended up getting injured, and what ended up happening is he was injured, and I'm trying to find my notes, but he basically he was a utility worker. So he ended up falling off a utility truck. He got injured, and then he went through the whole workers' comp process, and then eventually his doctor ended up releasing him to sedentary work. And so the next day after his doctor said he's capable of sedentary work only, the employer sent him a written light duty job offer, and I think they sent it by regular mail and certified, like a courier type of thing. So they certified regular mail, or certified mail rather, and then they had it couriered to that guy. And then the injured worker, this Mr. Lovell, after getting a description of what he was going to be doing, he decided not to do the job offer. And then what ended up happening is the employer, because he's rejecting the light duty job offer, the employer filed a motion to terminate his temporary total disability compensation. It went to the DHO, it went to the SHO, and the DHO found that this light duty job offer was, it was a good light duty job offer, and he rejected it, and therefore he's not entitled to comp. And then the SHO ended up affirming that decision, and so the injured worker Lovell filed a mandamus to the 10th district, and then here we are. So you want to know what the light duty job offer was. It's kind of interesting. So again, just a little bit of background on Lovell. Again, utility worker, that's his background. And then he went to high school, so he's a high school education, and then 2 years of college. And why am I telling you that? Well, here's the light duty job offer. The light duty job offer was, and this came out, the light duty job offer came out around I think it was 2021 when it was made. And it was basically, he was to read this revised code section, like 301. It's like a federal code section, and it applied to this health and human services issue. And their whole thing was read this revised code section, this federal revised code section, synthesize it, and then you're eventually going to end up making like a manual to advise the other employees at this company how to, fulfill the requirements of the revised code section as it relates to, COVID and the pandemic and stuff. So you'd think on the face of it, I don't know, that doesn't sound like a horrible thing. But it's a federal code section. And so in addition to that, he was required to, every day of his light duty. So here's the other thing. So it's sedentary, so it adheres to his physical restrictions of sedentary work only. It's reasonably close to his house. It's actually in his house, so it's a work from home thing. And then again, it adheres to his physical restrictions. And here's another little. This is where it gets kind of weird. So every day of this light duty work, he was supposed to take notes, and he was a minimum of 285 words a day, handwritten, I guess, per hour. So 8 hours times 285, 8 pages, and then times 5 days a week. And he was going to gather those, and each week he's supposed to give those to his safety manager at his employer, and they're going to review them for coherency and whatnot. So he saw this offer, and he's like, yeah, that's kind of weird. I'm going to reject that. And again, goes to DHO, SHO. They find that it was reasonable, and it was also helpful because in light of COVID and all that stuff, it would, this would be a good thing. I mean, that's essentially what they're saying is this is really great considering, in light of what's going on in the world. Um, and so it goes to the 10th district, and they do the whole analysis. And again, adheres to his physical restrictions. That's good. As far as the applicable code section. Um, and again, the code section that we're using is 4121-3-32A6. So it's here's his physical restrictions. It's reasonably close to his house. In fact, it's at his house, right? Reasonable proximity of the injured worker's residence, so he's literally in his house. It sufficiently describes what he's going to be doing. So, and then the issue is it must be made in good faith. So, what the 10th district and what this Lovell ended up found objections to the magistrate's decision, and the judges basically rejected most of the objections, but they did say there is a question about whether this decision or this offer is in good faith, and therefore it should. And their criticism of the DHO and SHO is the DHO and SHO basically made a cursory statement that it was in good faith. They didn't really analyze why it was a good faith offer, and so the magistrates or the 10th district, on ruling on the objections, bounced it back to the IC to explain in more detail why it would or would not be a good faith offer. And the relevance of that whole thing, here's the thing, here's the big takeaway of this case and these other cases that do deal with light duty job offers. The court has not defined what good faith is. So the Ohio Supreme Court, and they haven't defined what good faith is. They've given examples of what might be a light duty job offer made in bad faith. But ultimately, the issue of good faith, what the Supreme Court says, the Ohio Supreme Court says, is a fact issue. And a fact issue in this case, the decider of fact for this type of thing would be the hearing officers. So the hearing officers at the Industrial Commission, they're the ones who are the arbiters of what is in good faith or bad faith. So in what, again, they don't define what good faith is, but they do say, they give examples of what might be bad faith. And these are from other cases, and I've talked about in other videos, but it bears repeating in this video. One example of bad faith is they give you a job offer that they absolutely know you're not going to be able to do. And an example of that is they give you a work shift that you're not going to be able to work. Like, for example, you work first shift and they give you a third shift. And the reason why you work first shift is because you got to take care of your kids or something. And then another example that they give, that they don't necessarily say this is bad faith, but it raises the question that it could be in bad faith, and that is essentially, they're citing to this case called Pacheco, and what ended up happening in that case is this dude had, like, he injured his leg really poor, like it was bad, and somehow he had light duty of sedentary work only, so his employer brings him back to, like, the factory or wherever he's working. They stick him in the cafeteria in front of everybody, so this is the work cafeteria, and they just say, sit here all day. They don't really give him anything meaningful to do. And in that case, what he ended up doing is he just, like, basically, he's like, I'm not doing this, and he left. And so ultimately, I think what happened in the Pacheco case is because there was a delay between when he left and when he eventually saw his treating provider, who did say, oh yeah, he would have been temporarily and totally disabled and blah, 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 blah. He wouldn't have been able to do this. It was like 3 or 4 weeks by the time he got in there. And ultimately, his leaving to go whatever, leaving that light duty job offer in the cafeteria, ultimately his comp, the employer filed to terminate his comp, and his comp was terminated. But the court in that thing, again, they didn't want to define whether that was a bad faith offer to stick somebody in a chair in front of in a cafeteria looking at everybody, whether or not that's a good faith. But they did say it would raise the question, possibly, that might be in bad faith, doing so. So, and that's what they do here. And the reason in this case why they say there's a question of whether or not this is a good faith or not is, one, like this guy, he has, I'm not putting down Mr. Lovell, but he's got a high school education with 2 years of college, And what this employer is asking them to do is analyze and synthesize and be able to communicate what these federal statutes can be fairly dense text, and they're basically asking a utility worker to do a job that an attorney would typically do. So interpreting statute, and so they said that's kind of weird, and then essentially a lot of that sort of thing was there. It's just kind of an odd thing to have them to do, and there raises the whole question of this actual code section that the employer was having them analyze I think it was HR Bill 307. It's a federal bill, and it was published in 2013, and it was good time until 2018, and it wasn't passed in response to COVID-19 because obviously it was passed in 2013, and it really just addressed the authority and duties of the Secretary of Health and Human Services over again that period of time, 2013 to 2018. So the 10th District, the magistrate, and ruling on these objections and whatnot, they're like, how would this really be relevant to COVID and educating, your fellow employees and whatnot, notwithstanding the fact that you're asking this guy who may or may not be capable of physically mentally doing this, like the intellect in the background to do this. Well, it's like, what's the point? Like, it's almost kind of arbitrary at that point. So again, but the courts refuse to define what's good faith. They're always going to bounce back, and that's kind of the big takeaway from this is good faith is going to be defined by the Industrial Commission, and the biggest relevance to good faith, because to the implications of that is you get a hearing officer who might find that this is in bad faith because it's weird, because I think most of us would agree having like somebody who doesn't have a background doing this to do that is kind of strange. But that DHO or SHO, they might find that is not a good faith offer, so that a light duty job offer fails on that, whether or not it's good faith. But the other DHO, like they did in this case, DHO, SHO, they might say, that's a good faith. It's great. They're educating everybody about COVID and all this stuff. It's doing a great service for the employer and fellow employees. So based upon that, I don't know. Bottom line is there's a level of arbitrariness when it comes to who you get. And it's a big issue if the Industrial Commission is going to be the finder of fact. So anyways, that's this Lovell versus Industrial Commission 10th District's appeals case and objections. And I will post a link to that case in the description of notes. As I always say at the end of all these videos, workers' comp is a complicated beast. I highly recommend you don't do this on your own. Get an attorney involved. Ask your friends, family, neighbors, coworkers who they recommend. Get that person involved, who they recommend, and then talk to their attorneys that they're talking to you about. Look in Google, do a Google search on workers' comp attorneys. Figure out who you like, who you vibe with on the phone. Meet them in the office, sign up with them. But workers' comp, again, it's a complicated beast. I do not recommend you do this on your own. It's just too many details and variables. So, as always, I appreciate you listening to this video. It's been Kip from Malik & Malik. Thank you.